asking for an unlisted motion matter. Unlisted motion. 39, please. On the connected case, item number 39. It is also come. 39.
Did you receive one? Right, please. I beg to mention item number 10, my lord. Mr. Ekik Gupta has some personal difficulties today, my lord. Can you pass off for day, my lord? Item number 10, my lord. Ekik Gupta has some personal difficulties. R.S. Mishra, my lord.
Please, Your Lordship, I beg to mention item 11, my lord. Kindly, my lord, after 1 week. As is Sikher, my lord. My lord. I know, Lord.
I'm concerned of a criminal petition on Friday, Lordship. I beg to mention one IA for listing, along with criminal petition 272. It's filed. It's filed.
Please, Lord. Lordship, 439, 395, Lordship. PD, Lord.
My lord.
Ragi Road.
My lord. 20 of March.
Please. Yes, my lord. My lord. Yes, motion.
Of 2023, pending before the District Judge Sarayadao.
Sarayadao.
Stop. Issue notice returnable with 2 weeks. Mr. Das accepts notice on behalf of the respondent number 1. Extra copies within the course of the day. Stop. Steps by registered post AD in respect of respondent number 2 within a period of 2 days. List after 2 weeks and a date to be fixed by the registrar.
My lord. In the meantime, my lord.
Transfer petition, no stay. Next. Yes, revision.
My lord. 10.5 years conviction. Against conviction, my lord.
Against conviction.
2 years, 6 months, my lord.
Conviction is
2 years, 6 months.
2 years, 6 months. Conviction under
326, 341, 326.
all right, notice.
Fine.
This is an application under section 401, read with section 397 of CRPC, assailing the judgment dated 8/2/2024 passed by the learned additional session judge FPC Kachar Silchar in criminal appeal number 23 of 2020, whereby the conviction and sentence awarded by the learned subdivisional judicial magistrate M. Lakhipur Kachar under section 341, 326, 34 IPC was upheld. Stop. Issue notice. Returnable 2 weeks. Mr. Das accepts notice on behalf of respondent number 1. Extra copies within the course of the day. Registered post AD in respect of respondent number 2 within a period of 2 days. List after 2 weeks and a date to be fixed by the registry.
For IA for
Where is the IA?
suspension. Because he's outside.
He is
He's outside, my lord. Bail. He will be allowed to been on previous
He is already on bail
bail.
in the IA. In the IA, you write that this is an application under section 3971 of CRPC 1973 for suspension of the execution of the impugned judgment dated 8/2/24 passed by the learned additional session judge FTC Kachar at Silchar in criminal appeal number 23 of 2020 pending disposal of the revision petition filed before this honorable court and for allowing the petitioners to remain on previous bail. Stop. Heard
I'm N. Hawk.
heard Mr. N. Hawk, Learned Counsel for the petitioner, also heard Mr. D. Das, Learned APP for the state respondents. Stop. In the IA also we'll have to issue notice,
Not
or I can be disposed
not
of.
necessary. It is a daily matter between.
I have heard the submissions made at the bar and have perused the averments made in the interlocutory application and also the records and also the materials available on the records. Stop. In the interest of justice, it is provided in the interim that the execution of the order dated 8/2/2024 passed by the learned additional session judge FTC Kachar Silchar in criminal appeal number 23/2020 shall remain shall be suspended until further orders, and the petitioner is allowed to remain on previous bail till disposal of the until further order. In terms, in accordance with the aforesaid observation and direction, this interlocutory application thence disposed of.
May I please?
Yes.
Lordship, cause of action to file this petition is number 15.
Page number
15, Your Lordship.
5015.
15.
Yes.
It is the section of a Jimma Priya, Your Lordship, of my vehicle. And Lordship, that the reason for the Lordship denial to hand over the Jimma, Your Lordship, not recognition of the owner of the vehicle, Your Lordship.
Uncertainty of the ownership.
Yes, Your
Yes.
Lordship. It is my registration certificate is at case number, Your Lordship. 40.
Then you do, Mr. Das, let her file the registration certificate and let them.
Unnecessary or pending.
Lordship.
Yes. You are MSG Bora.
Lordship.
Heard MSG Bora, Learned Counsel for the petitioner. Also heard Mr. D. Das, Learned APP, as for the state respondents. Stop. This is a revision. This revision petition is filed under section 397 and 401, read with section 482 of the CRPC, praying for recall and cancel of the order dated 14/12/2023 in connection with Tejpur Police Station case number 797/2023 under section 379411 of IPC, read with section 11 of the Preservation of Cruelty to Animal Act 1960, read with section 13(1) of the Assam Cattle Preservation Act, passed by the learned Chief Judicial Magistrate, whereby the Jimma prayer of the petitioner in connection with the vehicle bearing registration number AS01FC0316 has been rejected. Stop. The case of the petitioner is that the petitioner is the owner of the seized vehicle and accordingly had filed an application for custody of the said vehicle before the Court of CJM Sonitpur Tejpur. Stop. The Court of CJM Sonitpur Tejpur, by order dated 14/12/2023, rejected the said prayer on the ground that the ownership of the vehicle could not be ascertained.
As it did not appear before the IOB.
Could not be ascertained. Stop. Mr. D. Das, Learned APP for the state respondent, submits that the ownership could not be ascertained as the petitioner did not appear before the investigating officers. Stop. Considering the above, accordingly, this court is of the considered view that this criminal revision petition can be disposed of with the direction to the petitioner to file the requisite documents before the investigating officer, and after receipt of all the relevant documents, the investigating officer shall report the matter back to the court of CJM Sonitpur Tejpur, whereupon the court of CJM Sonitpur Tejpur shall decide the matter afresh. So, as such, the order dated 14/12/2023 is set aside. It is needless to clarify that the aforesaid exercise shall be completed within a period of 1 month from the date of receipt of the certified copy of the order. From the date of receipt of the materials submitted by the investigating officer. So, disposed of. 5.
Your Honor. So this is an application for quashing of an FIR.
Yes.
And lastly, the case diary was called for. Diary has not come back.
Not come.
Not coming.
When can you place it, Mr. Das?
Sure. Put it. Release.
Await CD. List again on.
Also, 1 second, Milo. Sure. Could it be taken up at 2 p.m.? Perhaps CD is there.
Tomorrow.
Tomorrow, my lord.
Not tomorrow.
List tomorrow. Next.
May I please, Your Lordship? My lord, this petition for quashing of the complaint case in respect of the present petitioners only, my lord. And my lord, kindly turn to page 14, complaint petition, my lord, under section, my lord, 138, my lord, NI Act, my lord.
NI Act.
Our name, yes, our name we are, my lord, implicated, even though, my lord, we are not, my lord, any,
Will issue notice right now.
my lord.
And
We already
this,
resigned, my lord. We have already resigned, my lord, prior to my
very
lord.
well, we'll give you a short date on the next date.
My lord, my lord.
Let the respondent appear. This is an application under section 482 of Code of CRPC 1973 for quashing the criminal proceedings against the petitioner, being CR case number 6448/2022, pending in the Court of Learned Judicial Magistrate First Class, Kamrup, Metro, Guwahati, Assam. Stop. Issue notice returnable 2 weeks. Mr. D. Das accepts note. Learned APP accepts notice on behalf of respondent number 1. Extra copies within the course of the day. Registered post AD in respect of respondent number 2 within a period of 2 days. List after 2 weeks on a date to be fixed by the registrar.
My lord, interim order will be considered on the next date, my lord.
Next.
Obliged.
FIR quashing.
Kindly pass over a matter for that time.
Next. Yes, Ms. Som.
397 application. Okay. And impugned order is at page 19, Lordship. Speaking Jimma of the vehicle. And the petitioner is the registered owner of the vehicle.
Page.
Page 19 is the impugned order.
19.
Yes, Lordship.
Yes.
This case record up to date in the petition number filed by John praying for Jimma of vehicle.
No application of mine, Mr. Das.
And
The order rejecting, kindly see 16 to 24 at page 19. Is simply rejected because the case is pending.
Confiscation is pending.
Lordship. And
Trial he is taking.
Well, in fact, Lordship, petitioner is not implicated in the case. The factual background is that petitioner's vehicle has been hired by someone else. Those has been detained in connection. Petitioner was never asked for any purpose of any kind. And he has never been asked by the police or any authority.
Yes, it
Now,
does.
Lordship-
What I'm indicating is that you see, this does not
Lordship, the important
address the issue whether the vehicle is required
My lord,
to be kept in custody.
No, in the NDPS case, there is provision for, my lord, confiscation.
Lordship,
If the vehicle is,
Section 60.
my lord,
Is it section 60?
63 or
63.
65, I think.
I'm
One sec, Ms. Som. Yes, you want to say something?
Yes, Lordship.
Yes.
I want to place page 22, Lordship. Again, the code below observations.
Yes.
Order dated 22, whereby IO sought for paying confiscate the vehicle, and he said since trial is pending, that prayer has been rejected. So at the same time, Lordship, IO's prayer also rejected by the court below. That order, Lordship, would be pleased to find at page 22. May I read from the study?
Yes, yes.
Today is fixed for hearing. I am going to dispose of the petition filed by IO of the case of the following order. IO concerned of Dilai Police Station has made a prayer before this court for passing necessary order to confiscate the seized vehicle, Bolero car bearing so and so. The IO has mentioned in his prayer that during investigation it was learned that Jantiswara so and so is the actual owner of the aforementioned seized vehicle. The accused person was clandestinely transporting huge consignment of drugs from Manipur by engaging a conspiracy whereby supply of the drugs various parts of Guwahati, Assam. Also mentioned that during investigation the sample of seized drugs suspected heroin were sent to FSL so and so. Accordingly, prayed to pass an order to confiscate the seized Bolero car bearing registration. Hard learner so and so submitted that this is not the right time for filing such petition. An order of confiscation should be made after disposal of the case. From the pair of the IO, it appears that the owner of the vehicle, Sri Jantu Kaha, was informed about the seizure of the vehicle.
Confiscation has been denied.
IO, I agree. And accordingly, last page, Lordship, vehicle seized under NDP.
Yes.
Conclusion of the trial. And as such, Lordship, the petition of the IO has been rejected.
So now, pending this confiscation proceeding, your JIMA application
Pending-
has been rejected, which is that order
No,
you just
Lordship,
read out.
yes.
That order
Once
is
he
dated
said
19.2.
16.2 order says that confiscation proceeding is
So
pending.
to 16.2, and on
16.2 order
22,
says. And
the
22
confiscation has already been denied.
I'll be rejected.
So then why don't you file a fresh application before the special judge?
Let there be an observation that
Because it was only
Yes.
rejected on that ground. Heard Miss E. Som, learned counsel for the petitioner. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 482 of CRPC seeking quashing of the impugned order dated 16/2/2024 passed by the learned special judge NDPS Karbi Anglong Gifu in Dilai PS case number 07/2024 registered under section 21B of the NDPS Act 1985, whereby the application for JIMA of the subject vehicle was rejected. Stop. I have heard the submissions made at the bar and have perused the materials available on record. It appears that by order dated 16/2/2024, the Court of Special Judge NDPS Karbi Anglong rejected the prayer for JIMA of the subject vehicle to the petitioner merely on the ground that the confiscation proceedings of the subject vehicle is pending. Stop. Thereafter, on 22/2/2024, the Court of Special Judge Karbi Anglong rejected the prayer of the investigating officer for confiscating the subject vehicles. Stop. Thus, it is seen that the confiscation proceedings has already been disposed of. In that view, this court is of the considered view that this criminal petition can be disposed of with a direction to the petitioner to approach the Court of Special Judge NDPS Karbi Anglong Difu with a fresh application, and upon such application being filed, the Court of Special Judge so and so shall dispose of the same in accordance with law. This disposes of the criminal petition.
Deeply applied.
This petition for quashing of rule against the present petition, Lordship.
Yes.
Kindly, Lordship, come
Complaint case or FIR?
My Lord, CR case subsequent. Initially, FIR was there. That Lordship, for a moment, Lordship, kindly come to case 10, Lordship. Case 10, Lordship.
Yes.
In the name of accused, your Lordship will find there
Page
are
10.
Case 10. Type copy, Lordship.
Yes.
Your Lordship will find there are 5 accused in the
Land dispute.
land dispute regarding the among the brother law. Your Lordship will find there are 5 accused in the FIR. But in charge sheet, your Lordship will find is 15.
Anyway, we will only issue notice at this stage. Sorry.
Yes, Lordship.
No.
Lordship,
Not at this stage.
because the initial
This is an application under Section 482 of the Code of Criminal Procedure 1973 for quashing the proceeding in CR case number 604-2023 pending in the Court of Judicial Magistrate First Class Hailakandi. Stop. Issue notice returnable with 2 weeks. Stop. Mr. D. Das accepts notice on behalf of respondent number 1. Extra copies within the course of the day. Steps by registered post in respect of respondent number 2 within a period of 2 days. Interim prayer shall be considered on the next date. List. Give a date.
any date, Lordship, 2 weeks. Second of. Obliged.
May I please, Lordship?
Yes.
438 application, my Lord. My Lord, FIR page 10, my Lord.
FIR is
FIR page 10, my Lord.
420 409 406.
Allegation is that, my Lord.
FIR is at page 10.
Yes, my Lord.
Yes.
Allegation is that, my Lord. I have taken home loan, my Lord, 30 lakhs, my Lord.
You've taken a loan.
Yes, my Lord. Home loan, my Lord, from SBI, my Lord. My Lord, allegation is that, my Lord. It was NPA once, my Lord. And after verification, it was found that, my Lord, my land, in respect of which, my Lord, loan was granted, not my land. But,
Sorry, what was not yours?
my Lord, my land, in respect of which, my Lord, loan was taken, my Lord, that is not my land.
The mortgage land is not
My land.
your land.
Yes, my Lord. That is the allegation, my Lord. But case is not like that, my Lord. Kindly turn to page, my Lord, 17.
Mr. Das, let him appear.
My Lord.
Heard Mr. S.H. Sikdar,
My Lord.
Learned Counsel for the petitioner. Stop. Also heard Mr. Didas, learned APPs for the state respondents. Stop. Call for the CD fixing on
On 8th of April,
8/4/2024. Stop. Next para. Considering the total aspect of the matter, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case for a bail bond of rupees
30,000.
30,000 to the satisfaction of the
Authority.
arresting authority, subject of course to the following condition. Number 1, appear before the IO within 7 days.
My Lord.
Inducement, list accordingly. Yes, Ahmed.
438 application
Lordship, kindly come to page number 14. FIR is there, Lordship, at page number 14. There is FIR, Lordship. I read.
Yes.
With due respect, Ahmed submitted that just 3 years the accusation laughs, and on the pretext of marriage, 3 months ago at night times, the accused came to my house and left me against. After committing theft,
Which police station?
Lordship, may kindly put the last line.
I've seen. They're staying together. Huh?
South Salman.
No, last line. Now the accused person is hiding himself without solemnizing marriage.
Marriage. Now, Lordship, kindly come to connect with Lordship.
We are not getting. We'll give you a very short date, Mr. Ahmed. In this case, you will not get an interim.
The petitioner is student of BSc 4th semester, Lordship. And
Short
Lordship,
date.
He has not attained the marriageable age, Lordship. His age is 19 years.
Let us see the CD. Call for CD. List on
21st,
next week.
21st.
21st. 21st 3 2024.
Highly applied.
Yes.
438 application, Your Lordship.
Yes.
In connection with Jalukbari PS number 6, 22,
Yes. FIR at page 8.
page 13, will the Bhani.
Read the translated.
With due respect, I would like to inform you that on last 15/11/23, my brother-in-law Asmat Ali and me were waiting for going home over Jalukbari flyover. At that moment, a car which is Uber, white color Swift Desire, approached us and said that his car was empty and we
5,000 cash.
My lord.
Das.
Let the city come.
When? Jalukbari.
Jalukbari, my lord, on 20.
You know? Item number 14.
14.
Call for CD. List on
20. 20.
23 2024.
The interim protection.
7 days.
Yes.
Application, my lord. FIR is on page 8, my lord.
Page?
8, my lord.
Yes.
May I read, my lord?
Yes, yes.
With due respect, I beg to state that today on so-and-so at about 12, the accused person along with some other entered in the college campus suddenly without any permission and attacked me by pulling me from the veranda and took me towards the field by pushing while I was coming out from Assamese department to the veranda after keeping the register book after completion of my BS second semester classes. They also insult my...
Let him appear, Mr. Das.
The thing is that the informant is the teacher has been handled like this. In a
Informant is a teacher.
Yes, he is teacher. Assistant professor. The accused petitioner is a...
Call for CD. List on?
Oh, my lord. South Salman, no? My lord. 22nd March.
22nd 3 2024.
My lord. Protection,
Next.
My lord,
Wait for some time.
My lord. No, my lord,
Next,
it's similar case, my lord. My lord, same case, the out of same case, there is fixed on 15, my lord.
We'll give you on 15 then.
Okay.
Date to 15.
Along with my lord, AB number 449-224.
Along with AB number
449
of 2024.
Yes.
Yes. Item 16.
This is a protected BLB. FIR is number 19 to 17.
Page number?
9 to 17.
Yes.
Read it.
Yes.
With due respect, beg to state that the marriage of my daughter, namely Hutun Nessa, was solemnized with accused number 4. After marriage, the aforesaid accused person jointly had been torturing my daughter.
Call for CD. List on? Short date. List on? Save your energy for the next date.
My lord, 2nd of April.
2nd April?
My lord.
2/4/2024.
From Kasar.
All right.
major, Lordship.
Yes.
It was a consenting relationship between two majors, my lord. Subsequently, their family members did not agree to the marriage. Thereafter, this FIR was lodged, my lord. My lord will find the FIR at page 14. Family members were also implicated. They were granted bail, but I was denied bail by the.
You are?
I am, my lord, petitioner number, accused number 1, Aftab Ali Hassan.
Aftab.
Aftab, my lord. If I may read the FIR, ma'am.
Yes.
Sir, most respectfully, I beg to state that around 4 years back, the aforementioned accused number 1 had proposed to my daughter, such and such, promising to marry her, and accordingly they developed a romantic relationship. My daughter believed the accused number 1 and fell prey to his ways and taking advantage of the same. In the past, the accused number 1 took my daughter to different places and secretly developed physical relations. Meanwhile, he kept delaying their prospective marriage and continued maintaining illicit. Eventually, on 17/1/2024, while my daughter went to Corsilla College, the accused number 1 abducted my daughter at around 9 a.m.
The Nawaz CD. Call for CD, list on short date.
21st month.
Mr. Das, 21st?
22nd.
22nd, 3/20.
Deeply obliged.
Yes, Ms. Tom?
Yes, both the date application.
FIR is at?
FIR is page 12, Lordship, and petitioner is not with Lordship. List of the FIR is that, Lordship. The villagers of Taboka village wanted to beat one cow thief, and that is why, and police wanted to rescue that person, and there big mob occurred. And many persons from the adjacent villages occurred in the place of incidents. They witnessed the petitioner is one of them who witnessed the incident, Lordship. Now his apprehension is such, Lordship.
He is not named.
He is not named, Lordship. His apprehension is
Let him
such,
appear,
Lordship.
Mr. Das.
No, my lord, 326 is there. 326
Yes, but
is
his
there. my lord.
name is not there. Let him appear. If there is anything else,
we
we will see.
whether the man is alive, whether the man is
No one
alive
has
or
died, Lordship.
victim is alive or not, we do not know, my lord. So,
will
short that, my
appear,
lord, this is a
Lordship.
case
He
from
will appear,
Nalbari.
Lordship.
Within a week, I will produce the case.
He
then,
will
my lord.
appear, Lord. He will appear. He will abide by any condition, Lord. Because
320
liberty of personal liberty is concerned, Lord.
How many people were
Hundreds
named
of
in the
people.
FIR?
Hundreds of people been mentioned,
No,
Lord.
the FIR was lodged on 31st of January, 30 January. Till that he has managed. My lord, I hope
All right.
1 week he will be able to manage.
Call for CD, list on short date.
Yes, my lord, 22nd.
22nd. Yes. Next.
There is a FIR, cross FIR is also there, Lordship. The fact of the case is that, Lordship, just I am giving us Lordship. The informant, Lordship, they are cultivating ganja, Lordship. I am giving the data, Lordship, they are cultivating ganja, Lordship. The informant, Lordship, he and his brother, Lordship, family member, Lordship, they are cultivating ganja, Lordship.
They're consuming ganja.
Cultivating, Lordship.
Cultivating.
Cultivator, Lordship. They are professional cultivator, Lordship, and they are maintaining business, Lordship. Lordship, these fact, Lordship, the people of the village, Lordship, they objected, Lordship. But they did not any hate to them, Lordship. After some reporter went there, Lordship, and they reported it. And they published in the news, Lordship. Lordship, thereafter the FIR is lodged, Lordship. The NSRF, the annex, Lordship, it is the, I have taken it from the news channel, Lordship. Page, Lordship, 16, Lordship. This is the, Lordship, cultivating proof, Lordship. And this is the, Lordship, printout copy, Lordship, it will be never tell, Lordship. Lordship, they are professional.
Where you to appear?
Yes, Lordship. And
Mr. Das?
Mal.
That. Again. Heard, Mr.
Yes, Lord.
S. Hawk,
Yes, Lord.
Learned Counsel for the petitioner. Stop. Also heard Mr. Didas, Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting anticipatory bail to the petitioners in connection with Swalkuchi River PS case number 12 of 2024, registered under section 419-448-395-506 IPC. Stop. Call for case diary fixing on. Mr. Das, fixing on.
My lord, 2nd of April.
Fixing on 2/4/2024. Stop. Considering the entire matter, it is provided in the event of arrest of the petitioner named above, he shall be released on interim pre-arrest bail in connection with the above noted case on bail bond of rupees
30,000.
30,000, surety of the like amount to the satisfaction of the arresting authority in case of Didiba. Appearance 7 days, inducement, list accordingly.
Hello.
Yes, Mr. Das.
Wait, please, over. 438 application, my lord. FIR, my lord, is at page number 12.
304 Part B.
Part B. But however, my lord, marriage took place 8 years back, my lord. So prima facie, my lord, 304B is not attractive, my lord. The petitioners, my lord, are not the main accused, my lord. They are the relatives of the main accused. That is accused number 1. So still allowed.
Petitioner is
225, my lord.
225.
Yes.
Who are they?
My lord, they are the relatives, my lord. Father, mother, brother of the main accused, my lord. Main accused already arrested, my lord.
Mr. Das, the otherwise direct allegation is in respect of accused number 1. Alright. Heard Mr. S. Das, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC 1973 seeking granting of anticipatory bail to the accused petitioners, i.e. Gita Sailoba, 1, 2, 3 and 4 at page 2 as who are apprehending arrest in connection with Abhayapuri PS case number 71 of 2024 registered under sections 120B, 304B IPC. Stop. Call for case diary fixing on
My lord, 3rd of April.
3/4/2024. Stop. Considering the entire matter, in the interim, it is provided that in the event of arrest of the petitioners named above, they shall be released on interim pre-arrest bail in connection with the above noted case or bail bond of rupees 30,000 each and 7 days appearance.
Highly obliged, my lord.
Yes.
438 application letter certificate methodology and certificate has been laid by the police lordship under section 70 and 1.
Charge sheeted.
Charge sheeted. And lordship, the matter is pending for the learned judicial magistrate first class lordship and already someone has been issued lordship.
So you appear.
Lordship, I will appear, Lordship. I am ready to participate in the trial, Lordship, but we have been shown as absconder in the search. That is why, Lordship, I need some protection, Lordship.
Hearing appear till the date of appearance.
Third,
Lordship, protection may be granted.
Ms. D. Deka, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. This is an application seeking pre-arrest bail under section 438 of CRPC 1973 of the petitioners, namely 1, 2, who are apprehending arrest in connection with PRC case number 552 of 2023 under section 370-371 of IPC, pending before the Court of Judicial Magistrate First Class, Rongia. Within bracket, Rongia PS case number 918 of 2020. It is submitted at the bar, expired bar. It is submitted at the bar that charge sheet has already been submitted in this in the matter White's CS number.
Case number 293, dated 31/8/20.
Got it? And trial has started.
Trial is not, only summons have been issued.
And that summons have already been issued from the Court of Judicial Magistrate First Class, Rongia. Stop.
And next date of appearance is 10/5.
And that the next date of appearance is on
10/5.
10/5/2024. Stop. In view of the aforesaid submission, this court is of the considered view that it is considered that this anticipatory bail application can be disposed of with the direction to the petitioner to appear before the Court of Judicial Magistrate First Class, Rongia on the next date, i.e. 10/5/2024. Until then, the petitioner shall not be arrested.
On appearance, he will apply
it is
for
further clarified that upon appearance, the magistrate court is shall decide the
bail for regular,
shall
bail
decide
for
the
regular
matter for
bail on its own
bail
merit.
in accordance with law. Disposed of. Yes.
I am the Gauvura of a particular village, my lord. In that village, my lord, there was a dispute between two private parties. In this regard, an inquiry was initiated by the Office of the District Commissioner, my lord. My lord, before coming to the FIR, if I may draw your lordship's attention to page number 19, my lord.
Yes.
My lord, this is a notice which is issued by the Assistant Settlement Officer of Mankachar. Here, my lord, the notice was issued regarding a land investigation which directed to be conducted on 1st of February 2024. And the informant is number 2, my lord. Now, my lord, will kindly come
Shah Jahan.
Shah Jahan, my lord. Shah Jahan, it's Shah Jamal, but it's written as Shah Jahan, my lord. Now, my lord, page 21 is the next important notice, my lord. Here, my lord, it is first party number 1 is Nurul Khan, my lord. He is the one of the private parties, my lord.
Yes.
And again, number 2, Shah Jahan is there, my lord. Here, my lord, again the Assistant Settlement Officer issues a notice that there has been some construction on the land. So the parties have been directed that all construction work should be suspended, my lord. Now, my lord, my rule comes in at page 24, my lord. This is an order again by the Assistant Settlement Officer directing me to submit a status report of the land, my lord. You are hereby directed to submit a present status report in connection with the earlier notice, my lord.
Yes.
So I am a Gav Pradhan, my lord. I go to the place of occurrence to prepare a status report of the of the land, my lord.
Yes.
That very night, my lord, the informant's mother dies, and the informant lodges an FIR that because of the incident which took place on that day, his mother had committed suicide, my lord. My lord, I do not know whether this mother had committed suicide.
Where is the FIR?
FIR, my lord, will find that page. Page 13, my lord. But I was only discharging my official duty as directed by the Assistant Settlement Officer. I went there and prepared a status.
Let him appear, Mr. Das. Heard Mr. S. Nawaz, learned counsel for the petitioner. Stop. Also heard Mr. Vikas, learned APC for the state respondent. Stop. Call for the case diary. Fixing on
8 April, madam.
8/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner named above, shall be released on interim pre-arrest bail in connection with the above noted case of arresting authority, 7 days appearance and inducement.
I'm deeply obliged, madam.
The quashing of FIR at page 9, my lord.
Yes.
Case is that, my lord, the petitioner is the brother-in-law of the informant.
Page 9?
Page 9, my lord.
Yes. Yes.
The petitioner is the brother-in-law of the informant, my lord. He was called on that day to settle a, my lord, ancestral property-related issue, my lord. Thereafter,
Accused
my lord,
is Krishna Kanta Bora.
Krishna Kanta Bora, my lord.
He is the brother-in-law.
Brother-in-law, my lord. And his mother and the informant's husband's voter, my lord.
You are seeking quashing of this
Quashing
FIR?
of this FIR. My lord, it is false and concocted.
That is this while exercising jurisdiction under 482, is this court going to decide the veracity of the allegations?
Case diary will
within the
reveal
FIR?
everything, my lord. So I am praying for calling for a case diary.
I don't think any case is made out. The prima facie reading of the FIR indicates that there are averments which, if taken to be true, an offence is made out.
No, actually, these are false and concocted
That is
offences.
not. This is not the stage, Mr. Counsel. I don't think there is any merit in this application, Mr. Das.
I am praying for calling for a case diary, my lord, at this stage, my lord.
No. We will not unnecessarily issue notice. This is no case is made
Actually,
out.
my lord, this FIR is false and concocted. That is,
Mr. Gogoi, this is not the forum which will consider whether the allegations are true or the allegations are false. We will have to take these allegations to be true,
But
correct?
that is-
And then test it. Bhajan Lal, I don't
Lordship,
think we need to
kindly
go
see,
much
the
deep
case is
into all this
registered under
anymore.
376.
It's a well-settled law right now.
It
Yes?
is registered under 376.
Yes, there are allegations.
Allegation. My lord, lordship, kindly
So
see the
these allegations will have to be taken to be true on the face value.
No, my lord, allegation is that he entered into my bedroom and forcefully tried to establish physical relationship.
Notice returnable 2 weeks. Mr. Didas accepts notice on behalf of respondent number 1 and respondent number 2 steps by registered post. List after 2 weeks on a date to be fixed at the register. Uporot DD.
A case diary may be called for.
Next.
At this stage, nothing.
Public.
As directed by your lordship on the last occasion, Mother.
Very good. Huh? Yes.
As directed by your lordship on the last occasion, Mother, I have filed my affidavit yesterday, Mother.
I don't
Giving
think it has.
but it is not on record.
So,
Your lordship, since your lordship have already heard the other aspects of the matter, only this updated health status of mine was required. You can, the lordship can have it on tomorrow. The matter can be finished. off.
Tomorrow
the
we'll
matter
have
may
it.
be fixed after 1 week. We need to go through the affidavit.
Very well, Monday. List this. It is submitted by Mr. T. Goswami, Learned Counsel, for the petitioner that the affidavit, that an additional affidavit has been filed yesterday.
Yes.
Stop. Registry to verify and place the same on record. Mr.
M.H. Ali.
Mr. M.H. Ali, Learned Counsel, for respondent number?
234.
For respondent number 234. 6 some time for obtaining instruction on the additional affidavit. Stop. List this matter on 18/3/2024.
Totally over.
May I please, your lordship?
Yes.
Lordship, this matter is relating to the domestic violence, my lord. The matter, my lord, judgments was final judgment was pronounced as ex parte, my lord. On the date of the passing of the order, my lord, ex parte.
Can copy of records were called?
Call for, my lord.
Call for. Actually, I am already filed affidavit in opposition.
When?
Opposition.
When did you file?
Is already for tag in the.
Yes, it is there.
My lord, I have not received the copy, my lord.
You have not received?
Not, my lord.
Very well. Give him a copy. Your MS? S. Chakraborty. MS
But,
S.
Lordship,
Chakraborty, Learned
my-
Counsel, for respondent number?
Sole respondent.
For this, for the sole respondent submits that an affidavit in opposition has been filed.
Yes, sir.
Stop. However, Mr.
S.K. Jain.
Mr. S.K. Jain, Learned Counsel for the petitioner, says that a copy has not been furnished to him. Stop. Let a copy be furnished to the counsel for the petitioner. List this matter after 1 week on a date to be fixed by the registrar.
My lord.
But Lordship, there one judgment is there. Just area amount 2,50,000.
Very well, you-
Half of the amount
Ms.
has not been
Chakraborty, you
deposit.
first supply a copy of the affidavit. We will consider your matter after 1 week. First, give a copy of the
Date may be
affidavit.
fixed, Lordship.
All right, next.
My lord, in this case, my lord, I learned, my lord, my house have been blocked by the private responsibility by making a construction. The path, which is the only path, the ingress and egress of my families and other villages. Accordingly, my lord, I have filed a petition under 133 of the and
Anyone appearing on the other side?
my lord, notice served.
225.
Notice served.
And not there. We can admit this.
And my lord, I have the submission, my lord. For the
We'll
last-
admit, and because you see the petitioner respondents are also not there today. Oh, it's already admitted.
My lord, kindly see the order dated that 5/12 and 6/2, 5/12/2020 and 6/2/2020.
By which order it was
No,
admitted?
my lord, this court's order, my
No. By which order this matter was admitted?
Okay. That's the admission case.
Kindly see, my lord, page 6/2/2024. So
6
6/2/2024.
6/2/2024.
Yes, ma'am.
It says list the matter in admission column. But the matter is not admitted. I will admit one. I don't see any order. Right, admit, list this matter for hearing. Give a date.
Expeditious.
Before Bihu at a date. 9/4/2024. Yes.
This case, appear in the.
Sorry?
Mr. A. Ahmed argued case. He's on X. Time.
Time being or another date, Mr. Bora?
They're enjoying the stay, my lord. There's absolutely no case, my lord. There's
Friday?
Friday. Can it be kept to, my lord, or tomorrow?
I don't know what is the position of the list for tomorrow. All right, at 2 then.
All matters, my lord, they are challenging.
All right, we'll see at 2.
Please, your lordship. This is criminal appeal by the appellant suffered imprisonment for 5 years.
We'll pose the appeal for hearing.
Yes. In the meantime, IA may be considered. Please.
IA is there.
Yes, my lord.
IA was filed when?
At the same date, along with
30 January 24. We'll have it for hearing in the first week of April. And
in this case, my lord, lower court records will be required, my lord. And
all right.
My lord, kindly allow me a moment. This is a case, my lord. Involves case and counter case tried together by the same judge. And Nathilal's case was not being followed. So inevitable consequence of this appeal would be a de novo trial. My lord, in the meantime, my lord, my IA may be considered because on the previous day it was for motion and I could not appear because of my personal difficulty. And the matter was listed today after 3 weeks. But notice has not been issued.
Notice is not issued?
No, my lord. It was on the motion stage and I prayed for time for my personal difficulty and it was adjourned for 3 weeks.
There is no notice issued in this criminal appeal?
No, my lord.
All right. This is then how this matter has come.
It has been listed for admission.
Admission? How? Notice issue.
He was on previous bail, my lord. Anticipatory bail was granted by this honorable court, and he stood the trial, my lord. And he's a.
So your prayer is to remain in previous bail.
My lord, in the meantime,
he has been arrested,
suspended, my lord. Yes,
No, previous bill, but
he was on enlarged on anticipatory bail, and thereafter.
That is
my lord,
before
the
trial.
was
And after trial, you have been arrested.
Yes, my lord.
We are issuing notice right now. We will see later.
For suspension of sentence, let the LCR come.
That's right.
My lord, he is an employee of ONGC.
All right, I've heard you. Continue. This is an appeal filed under section 3742 CRPC for setting aside and quashing the impugned judgment and order dated 22/11/2023 passed by the learned session judge Charaideo in session case number 20 within bracket S-C of 2013 convicting the appellant under section 324307 IPC and sentencing to undergo simple imprisonment for a period of 2 years and also sentenced to pay fine of rupees 10,000 under section 324 IPC, and in default of payment of fine he shall undergo simple imprisonment of 1 month. So, issue notice returnable on
This, all right. My lord, 2nd of April, 3rd of April.
3/4/2024. Stop. Mr. D. Das accepts notice on behalf of the point number 1. Extra copies within the course of the day. Registered post AD in respect of respondent number 2 within a period of 2 days. Stop. list this matter after 2 weeks on a date to be fixed by the registry.
sentence may be
In
suspended,
the
my lord,
IA,
in jail,
you
my
say
lord.
that, and sorry, in the criminal appeal also say, scan copy,
LCR may be called for.
let the LCR of, from the court of,
From the court of.
Session Judge Choraido, my lord.
Session Judge Choraido be called for through the registry.
And the lower
In
court
the
record,
in the
respect
IA,
of-
you write that the that this interlocutory application shall be considered after receipt of the LC.
And in LCR, my lord,
Yes, next.
the LCR for counter case also may be called for, my lord.
I've said LCR, it will come. Next. The counsel, you give the number of both the cases to the court master. We'll put it in the order.
My lord.
Number the LCR.
Please, Your Lordship, my signature on legs that another. I need pass over.
To pass over, this is
For a similar order will be possible 7 years imprisonment, my lord. LCR will be appeal may be admitted and LCR may be called for.
no notice has been issued here. This appeal is under section 374 of the RPC against judgment and order dated 19/1/2024 passed by the learned session judge Kachar in session case 84. Issue rule, Mr.
No, appeal may be admitted.
Appeal?
Appeal may be admitted.
Yes, issue rule.
Not necessary.
Not necessary. Admit.
Admit. LCR may be called for.
Let the LCR be called to the LCR be called from the court of session judge Kachar through the registry. Stop. Notice is required in respect of.
There is no IA, I think, my lord.
No, but
Notice
in the
to
criminal
respond number
appeal,
2.
notice by registered post in respect of respondent number 2. Mr. Das accepts notice in respect of 1. Okay. List after 2 weeks on a date to. Court of restricted counsel.
Please, Your Lordship. This appeal has been preferred against the judgment whereby the appellant was convicted for a
Is
period
the IA?
along with the IA, Lordship. Lordship, here in this case, Lordship, already more than 50% of the actual sentence has been served by the appellant. So he is entitled for bail as per the mandate of the Honorable Apex Court. It is a law laid down in the case of Lordship the Sudan Singh.
Where is it? You are appearing for?
SC Girls, DRI.
Union of India, Lord.
I can't do
Lordship will kindly turn to page 4, Lord. Page 4 of the judgment, Lordship. Last para, page 4, last para.
Yes.
You may note that there may be even convicts in the custody cases other
Where,
than the
where?
life sentences. Other than the life sentence cases.
Which paragraph?
Last para, Lordship. Para number has not been marked.
Yes, yes, we may note. Yes.
We may note. We may note there may be even the convicts in the custody in cases other than the life sentence cases. And in those cases, again, the board parameter of 50% of the actual sentence undergone can be the basis for grant of the bail. Law has been settled by the Honorable Apex Court that if the appellant has already undergone the if more than 50% or 50% of the actual sentence, Lordship, he is entitled for the bail. Here in this case, Lordship, as on date, Lordship, the appellant has already
There is
undergone
no
5 years.
law as such settled, but it could be one of the grounds for
Lordship.
considering bail. All right, 50% sentence you have already
Lordship, 5 years, 11 months, 11 days, as on date.
5 years,
11 months, 11 days.
11 months,
11 days. As on
5
date.
years, 11
Month.
month,
11 days.
11 days.
As on date.
Out of?
Out of 10 years. 10 years is sentence.
The interlocutory gap.
Lordship, allow us 2 weeks time to file a.
What objection? In the IA, I am suspending it and granting him bail.
No, Lordship.
This is this case is otherwise under what section?
Lordship, he has been convicted under section 20B, Roman 2C of the NDPS Act. He was the handyman.
NDPS. And she has a right. 20C is there. We are giving a short date. Issue notice. You say notice in book. IA and notice. MS
T. Roy.
T. Roy accepts notice. Let extra copies be served with the course of the day. When do you want?
In
1 week. 50% they have already served. 1 week of list this matter on 28th, 2024.
We have already furnished a copy to them. Obliged.
Give them another copy, they may have objection.
Lordship.
Kindly pass up.
53. On another date then.
Against acquittal they have come, my lord. Dismissed for
Aspirate for list this matter again on after 2 weeks.
yes, after my lord. There are appellate.
After 2 weeks on a date to be fixed by the registrar. Stop. Your name is then you say aspirate for by MS DR Basumatari, which is not opposed by Mr. P. Kotoki. List this matter after 2 weeks on a date to be fixed by the registrar.
I think the last case, my lord. I like to what there is a bar in the DPS Act.
There is a bar, yes. No, you are talking about hearing the prosecution?
No, regarding sentence.
Regarding sentence. Thank you.
That you will also make an issue. Otherwise, it got be a wrong signal.
Very well. NDPS, that
32
bar
is... 32 is there, my 32 something like that. I forgot, my lord.
I
One of the cases I have argued.
Very well. Thank you.
Don't mind it.
Hearing.
30 minutes, short sheet submitted.
Short sheet submitted? Investigation is completed.
None appeared on behalf of the...
We can grant the bill, or should we give another date?
Because petitioner not appeared.
And appears for the petitioner when matter calls. Stop, list this matter after 1 week on a date to be fixed by the registrar. Diary?
No, my lord. In this case also short sheet submitted.
2 March 20. So then you don't, investigation completed. I don't think further detention required. Isn't it, Mr. Thakur? You won, right? You are Mr. H.R. Chaudhary. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Stop. Also heard Mr. Thakur, learned AP for the state respondent. Stop. This is an application under section 439 of the CRPC for granting regular bail to the petitioner in connection with Badorpur PS case number 259 of 2023, registered under section 448-326-307 of IP. Stop. I, Rushan Ahmed, Ellis Adai. Mr. P. Borthakur, learned APP Assam, submits that in the meantime, charge sheet has been filed by CS number
217 oblique 23 dated
2023. Stop. It appears that the investigation has been completed. In view of the above, further detention of the petitioner is not further custodial interrogation of the petitioner is not justified. Stop. Accordingly, the petitioner considering the total aspect of the matter, this court is inclined to grant bail to the petitioner. accordingly it is provided that the petitioner named above shall be released on bail in connection with the above noted case on furnishing of a bail bond of rupees 30,000, a surety of like amount to the satisfaction of
EJM
Karimganj with the subject condition. 1, 2, 3, this disposes of the bail application.
My lord, 54 in this case, my lord, as per my instruction, my lord, charge sheet not yet submitted. Today is, my lord, 88 days. Case diary not received. Case diary not received, but as per my verbal instruction, my
today is the
88 days, my lord, charge sheet not yet submitted.
And mandatory here is 90?
90 days.
Length of detention?
Length of detention.
FIR, Mr.
FIR, my lord, at page 11. Otherwise, my lord, in this
You are appearing for P. Sharma. FIR is at page
11, my lord. Is Nitul Das, my lord, involved in many other land.
Case diary has not come.
Not Then after tomorrow, that day, my lord, if charge sheet not filed.
List on
My lord, 15th of March.
15/3/2024. Yes. LCR?
Item number 32, my lord, LCR received.
Have you gone through?
Yes, my lord. As per the charge sheet, my lord, he is shown as absconder, my lord. 164 statement, my lord, she implicated. Although, my lord, 164 statement is not clearly legible, but from her 164 statement, she clearly implicates the present accused. And he is shown as absconder in this charge sheet.
Kindly say, my lord, page 12, my lord. I am a teacher, my lord. Regularly, my lord, serving my school, my lord. The police has never, my lord, come to my house, my lord, at any point of time, my lord.
That is all right. FIR is at page 14.
Page 14, my lord. I am a teacher, my lord. I am regularly attending my classes, my lord. Police has never come to my house.
Allegations are serious.
Lordship,
I filed an application for impleading.
I have serious objection against this
Lordship,
You are who?
Lordship, I am the husband of the victim, Lordship.
The husband of the victim, my lord. The victim has already filed 3 cases, my
let me
lord,
submit
against
my-
the husband, my lord.
Anyway,
My lord, this husband, my lord, this husband.
Mr. Borthakur?
Yes, my lord.
Allegation seems to be very serious.
Yes, my lord. Initially, my lord, he committed the offence of treason. Thereafter, my lord, after my lord, he recorded that video, and by showing
Blackmailing.
that video, my lord, thereafter, my lord, he repeatedly, my lord, committing that. Thereafter, my lord, on being mentally harassed, the victim informed her husband about the, my lord, incident. Thereafter, my lord, this FIR is lodged.
Sorry.
My lord,
This is not a case for
there is
anticipatory
one
bail.
submission, my lord. The husband, my lord, the informant, my lord, has filed 3 cases against the husband, my lord. But these 3 cases, my lord, has been filed, my lord. And I am ready to appear, my lord, before the court, trial court, my lord. Already investigation completed, my lord.
You are Mr. A. Khonikar.
My lord, investigation already completed, charge sheet submitted. I am ready to appear before the, my lord, and face the trial, my lord. I am a teacher, my lord.
This is not a case for anticipatory bail. The allegations are very serious. You appear.
My lord, this FIR is lost, my lord, on the behest of the husband, my lord. The husband, number 3 cases has been filed, my lord, against the
This
husband.
is for what?
My lord, one, my lord, DB case, my lord, 124, my lord, and one, my lord.
Who has filed these cases?
Informant, my lord. Informant filed the husband, my lord, against the husband.
That is a different aspect. But here, the FIR is.
Yes, on the behest of the husband, my
Mr.
lord.
Khonikar, the FIR has been filed by the victim herself. Victim statement has been recorded. So let us concentrate in this case.
Investigation completed, my lord. Someone has been issued, my lord. I will appear, my lord. On the date of someone, my lord, I will appear, my lord, definitely.
A. Khonikar, learned counsel for the petitioner, stop. Also heard Mr. P. Borthakur, learned APP for the state respondent, stop. case of the this is an application under section 438 of CRPC 1973 seeking granting of pre-arrest anticipatory bail to the petitioner, i.e. MD Mehboob Alam Lokor, who is apprehending arrest in connection with PRC case number 2358/2023 under section 376 of IPC within bracket Sonapur PS case number 148/2023 registered under section 376 IPC pending before the Judicial Magistrate First Class within bracket RC Fukan Kamrup M. We'll give the name. Kamrup M. RC Fukan. The case of the prosecution is that the informant filed an FIR on 26/7/2023 alleging that 1 year ago the petitioner made sexual intercourse with her by threatening and recording in his mobile phone. It is further alleged that later on the petitioner blackmailed her and raped her on several occasions by showing the said video. It is further alleged that when the informant objected to the said act, the petitioner threatened her by stating that he will upload the said video in social media. It is further alleged that the informant attempted suicide by consuming phenyl on 1/5/2020. Mr. A. Khonikor, Learned Counsel for the petitioner, submits that the charge sheet has already been filed in the matter, and as such, the petitioner may be allowed to, and as such, the anticipatory bail petition shall be allowed in respect of the petition. Mr. B. Borthakur, Learned APP, strongly opposes the prayer for the bail. He submits that there are materials available on record indicating implicating the petitioner for the alleged offence. He further draws the attention of the court to the statement of the victim recorded under section 164 of CRPC, wherein the victim has clearly stated that the petitioner has raped her and had taken a video of the whole incident, and thereafter by showing the said video has repeatedly committed rape on her. Mr. But you are not there in this matter.
I filed an application, Lordship.
That we will not see it. I have heard the submissions made at the bar and have perused the materials available on records. It appears from the materials that the petitioner has been absconding, and the charge sheet has been filed showing the petitioner absconder, correct?
Yes.
It further appears that there are sufficient materials implicating the petitioner in the alleged offence. The allegations, the nature and gravity of the offence alleged is grave, and considering the same, this court is not inclined to grant anticipatory bail to the petitioner at this stage. As such, the anticipatory bail application stands rejected, disposed of.
And IIA may...
In view of the order passed in the AB, the IA stands disposed of.
This case, my lord, case diary not received. Petitioner is in interim.
Await case diary, interim order, if any, shall continue. List the matter on?
On, my lord, 23rd of April.
23/4/2024.
Article also, my lord, case diary not received, my lord.
On interim?
Interim,
Yes, my lord, I am on interim.
Await case diary, interim order, if any, shall continue till then. List on?
23/4, my lord.
23/4/2024.
Obliged.
Yes.
He was called.
In this case also case diary not received. Petitioner is in interim.
Await CD, list again on?
on my lord 22nd of
22nd 3.
Yeah, 24.
22nd 3 2024.
Yes,
Yeah.
yes.
Till then, interim order passed earlier shall continue.
22nd 4, my lord.
22nd 4. Yes.
Lord, 36, my lord, search sheet submitted, my lord, in this case.
Charge sheet submitted?
Yes.
You appear then. Till then, we'll protect you. Heard Mr. P. Das. P. Das, Learned Counsel for the petitioners. Also heard Mr. P. Borthakur, Learned APP for state respondent. This is an application under section 438 of CRPC 1973 seeking pre-arrest bail of the petitioner, namely Khudeja Begum, who is apprehending arrest in connection with Chayagaon PS case number 26/2023, registered under section 304B/34 IPC. Stop. Mr. P. Borthakur, Learned APP, submits that in the meantime charge sheet has been submitted by everyday CS number
246/23, dated 18/7/20.
246/23, dated
18/7/2023. Yes.
Mr. P. Das, Learned Counsel for the petitioner, submits that the petitioner is willing to appear before the trial court and cooperate in the ongoing trial. Considering the above, this anticipatory bail application is disposed of with the direction to the petitioner to appear before the court of
Kamrup at Amingaon Lodge.
Before the court of CGM Kamrup within bracket Metro.
No, Lord. Kamrup at Amingaon.
Before the court of Learned CGM Kamrup Amingaon. Within a period of
15 days, Lord.
In a period of 15 days, until then he shall not be arrested. Stop. Upon his appearance, the court of so and so shall consider the prayer for bail in accordance with the law. This disposes of the anticipatory bail application. Are you ready or after some time?
Well, after some time.
After some time, all right. 37 after some time. But 38 আছে? In 38?
Yeah, please.
Yes, case diary?
Yes, my lord, case diary received, my lord.
FIR is page number 11, Lord.
Page number?
11.
11. Yes.
The accused number 1 is the father-in-law and the accused number 2 is the brother-in-law. And the complainant himself, now there an affidavit also, an advocate also appear on behalf of our law. The allegation is completely false. Some investigation, we filed this.
He has now stated it is.
Yes.
He is not supporting
My
her
lord,
version.
in her 164 statement, 161 statement, she has made so seriously implicated both the accused person. Now, my lord, she filed compromise petition that I have no grievance against all these petitions. So initially, my lord, in her FIR 161, 164 statement, she clearly implicated both the accused persons, my lord.
Where is that
After police
affidavit?
has investigated the entire matter.
Where is the affidavit?
Affidavit is page number 15.
FIR is at page 11.
15 is the...
Page 11 is the FIR.
Yes, 15. Page number 15. They're living in same house, possibly joint family. Now they are...
Father-in-law, brother-in-law, all rape.
Yes. And let the victim appear before the first, my lord, before the police again, my lord, or otherwise before the trial court and make her statement.
They appear, Lordship.
Where is the affidavit? Where is the affidavit?
The affidavit.
And my lord, in many cases it happens that my lord, out of my lord threat, out of coercion, my lord, this type of affidavits.
Then we keep this pending.
Yes, my lord. Let her again appear before the trial court to
trial court,
the police station, my lord, to record her statement again, my lord.
They appear before the police station. As per last order, Lordship, the Honorable Judge, Lordship, verbally instructed to appear before the police, but it is not taken this one, Lord. They deny.
We will.
Both the party along with.
Very well, we will.
Lordship may direct and.
We will direct and in this anticipatory bail application, you say the learned counsel for the petitioner has drawn the attention of the court to the affidavit which has been filed by the informant.
Yes.
By the informant, to the effect that that she had filed the FIR due to misunderstanding against the petitioner, against the petitioners.
Yes.
Against the petitioners. Stop.
Father-in-law and brother.
Against the petitioners, i.e. father-in-law and brother-in-law. Stop. Mr. P. Borthakur, learned APP for the state respondent, submits that the 164 statement of the victim is available in the case diary, which indicates that the petitioners have repeatedly raped the victim. Stop. Yes. Considering her affidavit, this court is of the considered view that let her statement be once again recorded by the jurisdictional investigating officer and a report be submitted before this court. Stop. Accordingly, list this matter after 2 weeks on a date to be fixed by the registrar.
I have no interim order. The interim may be considered. In the meantime, we will take care.
Nothing. Yes.
May I please, Your Lordship? Last diary was called for, Lord. FIR, Lordship, as is number 40.
Case diary?
Yes, 39.
39, I think there's an unlisted matter connected to 39. So we'll call this when the unlisted.
40 my lord, case diary not received.
Not received. Are you on interim, Mr. Ahmed?
No, Lordship.
Short date.
Lordship, consider the interim prayer members.
Call for the await for CD. List this matter on short date. 23/2024.
Highly obliged.
Kada apuna
55. Yes. CD?
CD is there, my lord. On that day,
my lord, last day, yesterday it was there. So, my lord, I made a statement that they have made a went to the before the IO and they have given.
Right, Mr. Das said
he's appeared.
He's appeared.
And I'm on interim, my lord, interim order.
And his statements have been recorded. What is the finding of the investigating officer?
I am not named.
Huh?
I am not named in the.
Not named.
Only thing is that the IO has some objection because this is a serious mob lynching. I mean, my objection may be recorded.
This is that uniform.
Uniform,
yes. Photographs are there, below. Uniform.
Where is the FIR?
FIR is at page 12, my lord.
There are two anticipatory bail applications.
My lord, another one, the second one is, my lord, he is also not named, but he is a HIV patient. Both are under interim and they have given their statement.
FIR is at page 12.
12.
The police person informant was not manhandled, below.
No, but the petitioners are there in the photographs.
They are this way, below. They were.
This way, I understand, but is the petitioners there in the photograph?
Personal attribution is not there.
Then not punishment. Yes. $200 people. Heard Mr. P.K. Roy Chaudhary, Learned Counsel for the petitioners. Top. Also heard Mr. D. Das, Learned APP for the state respondent. Top. This is an application under section 438 CRPC filed by the petitioners, namely 1 and 2, praying for pre-arrest bail who are apprehending arrest in connection with Bajarichara PS case number 6 of 2024 within bracket corresponding to GR case number 39/2024 registered under sections 147, 148, 149, 152, 341, 353, 307, 332, 394, 36, 511 I. The case diary call for placed before the court. It may be mentioned that by order dated 6/2024, this court granted interim pre-arrest bail to the petitioners subject to conditions. Mr. P. Das, Learned APP for the state respondent submits that the petitioners have appeared before the investigating officer in terms of the interim pre-arrest bail granted by this court earlier. The statement, he further submits that the petitioner's statement has been...
Perhaps statements are not reviewed. I did not find the statements. Their statements. They have appeared because certified copy of the interim order they have submitted. To that extent, I know. But whether statements are recorded or not, on condition that they will appear as and when.
All right. Don't say that you say. He further submits that so there are no adverse materials till now collected as such against them. He further submits that no adverse material has been collected at this stage against the petitioner's name. Against the petitioner. Considering the above, this court is of the considered view that custodial interrogation of the petitioners may not be required for the ongoing investigation. Next para. Accordingly, it is provided that in the event of accordingly, the pre-arrest bail granted earlier by this court by order dated 6/2024 is made absolute, subject to the following conditions. This disposals of the anticipatory bail application. And which is the other one?
AB number 17.
Everything will remain same except the name.
And the interim order is 23/120.
Yes. Here, petitioners are different. Is one. Okay. Only one, right?
One.
Monohar Ali in item number 6. And the interim order date is 21/2/2024.
23/120.
23/120. Sorry. OP 23/1/2020. This disposes.
Obliged.
Register section under my lord 376 and 448. Petitioner showing my lord absconder has filed first statement.
File, my lord. I have gone through the LCR, my lord. It's a bad case for anticipatory bail, my lord. 164 is implicated. Incident on, my lord. Incident happened on, my lord, 16/9/2020. Medical immediately on the next day on 17/9/2020. As per the medical report also, my lord, as per the opinion, my lord, there are signs of recent forceful penetration of the vagina. So,
but investigation is completed.
Investigation completed, but he is still absconding.
Let him appear before the court and we'll protect him till then, and after that, let my lord below consider. Heard Mr. M. Kalita, Learned Counsel for the petitioner's also heard Mr. K.K. Parashar, Learned AP for the state respondent's This is an application under section 438 CRPC 1973 seeking pre-arrest bail of the petitioner, i.e. MD Bhaji Bhaijan Ali, who is apprehending arrest in connection with Tinsukia PS case number 1024 of 2020, corresponding to GR number 1768 of 2020, registered under sections 448, 376 of IP. Now, Mr. Next paragraph. Mr. KK Parashar submits that in the meantime, charge sheet has been filed by its CS number?
CS number, my lord, 567 of 2023.
567 of?
23, my
23. Stop. It appears that the investigation has been
Investigation completed. We have received the scan copy also, my lord. I have gone through the scan copy. There are 164 statements as well as the medical man.
Stop. In view of the above, it is directed that this anticipatory bail application is disposed of with the direction to the petitioner to appear before the court of
CJM
Tinsukia until within a period of 10 days. Until then, he shall not be arrested. Stop. Upon appearance, the court of CJM Tinsukia shall consider the prayer for bail on its own merit. Stop. This disposes of the anticipatory bail application. Yes, Mr. Ahmed.
There is a delay of 89 days. Their name has been gone in the cause list.
Okay. How many days? 89 days.
89.
Heard Mr. J. Ahmed, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. Although the name of the lawyer, name of the counsel for respondent number 1 has been reflected in the cause list, none appears when the matter is called. Stop. It may also be mentioned that on the last occasion, I-7/3/2024, also none had appeared on call for the respondent number 2. Stop. Next para. As such, the IA for condonation of delay is taken up for hearing. Stop. This is an application filed by the petitioner in connection. This is an application filed by the petitioner for condonation of delay of 89 days in filing leave petition.
Yes.
Leave petition to file an appeal against the impugned judgment and order dated 31/2009 passed by Judicial Magistrate First Class Bhakta Musalpur in CR case number 103/2018 within bracket old CR number 56 of 16. Stop. Mr. J. Ahmed, learned counsel for the petitioner, submits for that. The facts of the case is that the applicant had filed a complaint case being CR case number 103 of 2018 in the court of SDGM Balaji Patsala on 9/3/2016. Stop. Accordingly, cognizance was taken and charge was framed under section 494506 of IPC against the respondent number 1. After hearing the parties, the learned trial magistrate acquitted the respondent number 1 from charges by judgment and order dated 31/2019. Stop. Stop. Being aggrieved by the aforesaid judgment, the petitioner is filing the application for leave wherein there has been a delay of 89 days. Stop. Accordingly, the present condonation application has been filed. Stop. Mr. J. Ahmed, learned counsel for the petitioner, submits that the delay is unintentional and occurred beyond unintentional. Stop. He further submits that the petitioner, due to poverty, could not come to Guwahati and engage the lawyer for which the delay occurred. Stop. Mr. E. Borthakur, Learned APP for State Respondent, submits that he has received no instruction to oppose the prayer for condonation of delay. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the petitioner came to know him. Sorry. It appears from the averments made in the condonation application that the petitioner, after having come to know about the judgment and order, comma, applied for the certified copy, and after receipt of the same, petitioner collected the same from her engaged lawyer. Stop. However, due to personal difficulty, the petitioner could not meet the engaged lawyer on 26/4/19, and on that day the engaged counsel hand over the certified copies to the petitioner on 1/5/19. Stop. Thereafter, the petitioner fell ill and as such could not take any steps. Stop. However, later on, after consulting with his family members, he met a lawyer at Patsala, and upon his advice, he had come to Guwahati. He had come to Guwahati to engage a lawyer. Stop. However, due to his financial condition, the appeal could not be filed within time. Stop. Next para. The aforesaid grounds appears to be sufficient and unintentional. Stop. Accordingly, in the interest of justice, 89 days delay occurred in filing the leave application is condoned. Stop. Application allowed. Registry to register the connected leave application. This disposes of the interlocutory
The
application.
petition is there, my lord. The petition number is there.
Is there?
Yes.
That we will take up on another date.
That case also notice was issued to them.
272 is the delay.
Delay.
All right. Today only that is in front. Don't say registry to verify. You say that let the leave application be listed. Yes, 42. Case records were called.
LCR received.
Then we fix it for hearing.
Yes.
The case records call for has been received. Stop. Paper book required.
Yes, well.
Let registry prepare a paper book and thereafter list the matter for hearing in usual course.
The paper book not required because imprisonment is for 3 years.
Not required.
Not required.
List paper book list for hearing.
Here is 75 days delay to file revision.
Notice.
Yes, I am appearing.
You are appearing. Any objection? 75 days. Paragraph.
Pilot 3, 4 and 5 I have it.
was filed on 18/5/23. Okay. Heard Mr. M. Hussain, Learned Counsel for the petitioners. Also heard Mr.
T. Borua.
D.
T. Borua.
T. Borua for the
T. Borua.
D. D for Delhi. Mr. D. Borua, Learned Counsel for the respondent. Now, this is an application under Section 5 of the Limitation Act 1963 for condonation of delay of 75 days in filing the connected criminal revision. Now, the facts of the case is that there occurred a delay of 75 days in filing the connected criminal revision petition. Stop. The grounds of delay averred in the condonation application is that the engaged advocate did not inform the applicant about the delivery of the judgment, and since the applicant had engaged the lawyer and was hoping that he would inform the developments of the case, did not further check with him. However, when the police came to arrest him after the passing of the judgment and order dated 30/11/2022, he came to know about the same. Accordingly, thereafter, after arranging the the appeal was filed. However, in the meantime, a delay of 79 days occurred. Mr. D. Borua, Learned Counsel for the respondent, has instructions not to oppose the prayer of condonation. I have heard the submissions made at the bar and have perused the materials available on record. The grounds averred in the condonation application appears to be bona fide, sufficient. Accordingly, in the interest of justice, the delay of 75 days is condoned. As such, application is allowed. The criminal appeal is registered. Revision is registered. No. Registry to register the connected criminal revision. We'll come back in 5 minutes. Bora?
Yes.
IA.
IA for the suspension of the conviction, my lord, where in a NDPS case, my lord, he has been convicted for 10 years. That case, my lord, whether the state would like to file the objection, I don't know, my lord.
LCR has already been received.
Yeah.
I got it.
Mr. Bora, in case of EPS,
yes,
at bar under
I heard that's what I am just to.
There is some decision of the Supreme
That has been
Court.
overruled, my lord.
That has been.
That is overruled, my lord. That is, I don't know why he is.
Are you referring to Dadu?
Yes, Dadu, yes.
My court
Yes.
has
Dadu has been at the
traced out.
constitutional bench has overruled that provision.
Yes.
That is in-
I did not have the time to
Yes,
look
His
into
Lordship
it, but no.
yeah?
My court master has already given.
Excellent.
Anyway, you want to file your objections?
My lord, LCR has been received. Now 10 years punishment. May I submit, my lord, the entire matter? He wants, my lord, bail on merit. So if on merit, my lord, we have to go through the minor details of the evidence on record.
Only
So
one.
the entire matter may be disposed of within a week or 2 million.
That
For a hearing
will
day.
be possible. That is the difficulty. Your Lordship knows it comes.
For bail, you have a look at the LCR.
Well, my case is that here is the car has been entered and the matter has been recovered from a car. The whole judgment is regarding the compliance
You were
of...
not inside that car.
I was in car. But regarding...
Then it is from your possession, Mr. Bora.
Regarding the compliance of section 42. So there is a judgment of the Supreme Court. Absolute non-compliance of 42 is entitled for the acquittal. Here is an absolute non-compliance of the 42.
Otherwise, prima facie, the court has already convicted you.
Convicted me, there's a 42 has been complied with. Absolutely perverse. Nobody
I
even
think,
said. Not a
after
single...
will take some time. Maybe then let us try if we can. Ajit is create a hearing.
Not even a single whisper by a witness.
The difficulty you understand it is NDPL.
Well,
The
that
conviction also it is very strong. Now it is already
yes,
convicted.
They can show it, man, that there is even this
What
slightest...
I am proposing
Yes, yes, yes,
Bora,
I'll show it. It has
is
been
that
complied.
we will make an attempt to hear the
Because
entire
of-
matter
Yes.
next week. In case we cannot, in that case we will consider the prayer for bail. Otherwise, we'll try and finish it next week. Next week, not possible. So you give it on a motion date at a hearing.
4th of April?
Is 4th April all right? Bora?
4th of April.
An item 5. List the criminal appeal, connected criminal appeal for hearing on 4/4/2024, along with the I criminal 971 of the. We will make an attempt.
Yes, that attempt will be...
It is made clear that in case the hearing, that an endeavor will be made on that day to dispose of criminal appeal.
May I submit?
On that.
Evidence on record are in English. If the registry necessitates the photocopies of the as in the form of
Paper book.
That will save time.
That will not. I don't think by 4th they can.
Only photocopies, Milord.
Xerox, you want the Xerox?
I have...
All right.
I have filed all the certified copy in my... All the copy. Evidence.
You want a Xerox copy? Registry
If I
is directed to provide Xerox copy of the lower court records to the office of the public prosecutor Assam. Before the next date.
That means without going...
No, my Aadhaar police.
Aadhaar.
5 teaser witness police.
That is not a complaint.
For this email petition filed under 482 RBC for quashing of an affair, being the cognizance order that is passed by the learned trial court.
Why has it come for orders?
My lord, so far the office dated 11th of March, service report is awarded and can also
Await service report and scan copy of case record. List again on after 4 weeks and a date to be fixed by the registry.
Lordship may fix a date.
Anyway, let it come, the registry will fix it. Next.
All right.
Yes, Mr. Vauthakur.
7 and 48
Why are these criminal petitions for orders?
Orders should have come in the admission column, Your Lordship. These are, Your Lordship, we have challenged the proceeding in a case, Your Lordship, registered under
Notice and service, everything is complete.
Lordship. Process to take it up in
So
admission
there is an
column.
office note of 12 January. No fresh steps for issuance of notice upon the newly impeded R3 and 4.
Already imprisonment, and they have appeared also, Your Lordship.
3 and 4.
3 and central government and
Is it Mr. Deenat?
Yes, Your Lordship.
Deenat is for?
State government.
Respondent number?
Respondent number 3, Your Lordship.
And
4, Your Lordship. And respondent number 3 is the central government, Your Lordship.
Mr. M. Fukan. No.
No, Your Lordship, RKD Chaudhary appeared on.
TYSGI.
Lordship.
Though the office note dated 12/1/2024 indicates that steps has not been taken in respect of respondent numbers and 4, comma, it is submitted by Mr. S. Borthakur, Learned Counsel, petition that Mr. D. Das, Learned Counsel, Mr. D. Nath, Mr. D. Nath, as senior government. The Dinat senior government advocate has entered appearance for respondent number 4 and Mr.
RKD
Chaudhary, SGI, DYSGI, Learned DYSGI has entered appearance on behalf of respondent number 3. Stop. It appears that their names are also reflected in the cause. Stop. As such, service is completed. Stop. List this matter for admission. Admission.
Lordship, admission column.
Admission when? Next, after 2 weeks.
On 20th, can it be possible? Because Your Lordship, a proceeding has been paid.
Sir, both matters here. After 2 weeks on a date to be fixed by the registry. Yes.
If Your Lordship, after 2 weeks, date can be.
It's difficult, Mr. Borthakur. They will list it. Any problem, you come.
48, Your Lordship, 148 interim order is there. Your that
interim orders, if any, shall continue till the next.
Lordship.
Yes. 49. Nicola, 49. Yes.
Lordship, this is a criminal petition. Lordship, in this matter, service awaited, Lordship.
Await service report list after 3 weeks on a date to be fixed by the registry.
A date kindly.
All right, next.
Lordship.
Lordship, I could not take step respondent to.
You have taken?
No, I have not. I could not take it to date.
It is your name?
N. Karanwal. N. Karan.
Your name is not reflected here. It is submitted on behalf of the petitioner that steps shall be taken within the course of the day in respect of respondent number 2. Stop. Prayer allowed. List this matter after 3 weeks on a date to be fixed by the registrar.
Thank you, Lordship.
Yes.
Letter has come for today condemnation of delay.
2,161 days.
Substantial delay is there, but not without grounds. Actually, the council
without grounds.
It's not without grounds, I'm telling. Actually, what happened? The council was engaged to conduct the appeal. That council was ailing for a long time, and thereafter, he subsequently he expired also. But that information was not received by the petitioner, and
So because of want of knowledge, the delay occurred.
The want of knowledge mainly. But after he
respondent number 2, anyone appearing?
No. Today,
First time.
Notice in
All right. This is an application under Section 5 of Limitation Act for condoning the delay of 2,161 days in filing the connected criminal revision. Now, issue notice. The K.K. Parashar, Learned APP, accepts notice on behalf of respondent number 1. Steps by registered post in respect of respondent number 2 within a period of 2 days. List thereafter on a date to be fixed by the registrar.
But another I is there for suspension of the sentence. That part.
Let the delay first be condoned. How can we consider that without your delay being considered?
Because warrant is there, man. It is.
Sorry.
Without issuing the number.
Because of the warrant.
Counsel, you are aware of the procedures. Next matter, please.
Item 39.
Yes, Mr. Bora, what is this bail?
What's the 439 application?
We'll first take up 760.
760. What's the 439 application? 33 days behind the bar. Page number 9.
So, the 760 is AB or bail?
Bail application.
Right. Anyway. What is this? There is a...
Once we turn to page number 9 in the FIR, the allegation is that command certificate for Home Guard was issued.
Just 1 second.
AB item 39.
AB
is item
446?
AB is item 39. Yes.
Oh, item number
446.
446, that is item number?
39.
That is item 39. That came in. So we will take which one first?
BA.
BA.
Prakash,
760.
760.
Yes.
Page number 9 in the FIR, madam. Allegation in the FIR that a command certificate was issued to the Home Guard.
Page number?
9.
Yes.
Command certificate is issued to the Home Guard. And actually the fact is that 16 command certificates are issued, but they have received 63. These are commands, they are all fake. That is the allegation.
63 command certificate.
By the what Home Guard volunteers were received by the police reserve, Ozali. In fact, it was only 16 was issued. That is the allegation.
Actually, only 16 were.
Actually, only 16.
So fake command certificate.
Fake command.
Mr. Parashar,
my lord, yes.
you need how many days?
33 days.
You need
both are
for other detention. And in the other one, you are willing to surrender.
My lord,
you are willing to appear and cooperate in the
anticipated.
They are definitely relevant.
Prakash statement I have seen. Solindra one is there.
There are how many petitioners, Mr. Bora?
Two.
In fact, in page number 12, my lord, there is a production they have said in the second paragraph itself. During remand period, the accused persons were thoroughly interrogated, and the statements are also recorded.
It's on length of detention. Otherwise,
That is what? That is 30 days and... Alright. Heard Mr. S. Bora, learned counsel for the petitioner, OP. Item number 1 of the production. Heard Mr. S. Bora, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondents. Stop. Sit down. This is an application under section 439 CRPC 1973 for bail of the petitioners 1 and 2 in connection with Patsala Police Station case number 15/2024 registered under section 120B 409 468 471 of IPC. Stop. Huh?
No.
The case of the prosecution is that one is that an FIR was lodged on 8/2/2024 inter alia alleging that upon verification it is found that when only 16 command certificates are issued by the Commandant Home Guard Urban Wing or PETA, 63 numbers of command certificate of Home Guard volunteers were received at Police Reserve Office Bajali. Stop. Accordingly, a case was registered. Stop. Mr. S. Bora, learned counsel for the petitioner, submits that the petitioners are languishing at jail since last 33 days. Stop. He further submits that the statements of the petitioners have already been recorded under section 161 CRPC and the investigation appears to have been concluded. Stop. He further submits that the petitioner are not involved in the offence alleged and only on suspicion they have been arrested. Stop. Mr. K.K. Parashar, on the other hand, strongly opposes the prayer for bail. Stop.
There are materials.
He submits that there are materials available on record implicating the petitioners for the alleged offence. Stop. I have considered the submissions made at the bar and have perused the materials available on record. Stop. It appears that the petitioners have been thoroughly interrogated and their statements were also recorded. Stop. considering the length of detention and the entire aspect of the matter, this court is inclined to grant bail to the regular bail to the petitioner. Now, accordingly, it is provided that the accused petitioners named above shall be released on regular bail in connection with the above noted case on furnishing of bail bond of rupees 30,000 each, with like satisfaction of PJM Bojali Patsala, subject to following. This disposes of the bail application. Yes, next.
This is Konkon Padgiri. This is
item number
39. This is anticipatory and that Prakash Kolita already allowed, and this Konkon Padgiri. They have distributed the fake command among the Humgars.
The allegation is?
They have taken some money and distributed those fake command certificates among the person Humgars.
The petitioner?
He is also one of the, and one is allowed that arrested Prakash.
He along with him?
Prakash Kolita along with this.
Let him appear then.
I will appear. I will appear for the IO as
because the allegation is the same for both. We have already granted bail to the other one. The only difference is that he's still outside, but the object of bail is also to secure the appearance, correct? By a reasonable bail amount. So we will. You are assuring.
Yes. I am
willing to cooperate.
Yes. As and when required, I will appear for the IO.
Not as and when. First, you will appear within 7 days.
Yes, definitely.
You have not yet appeared. You first
I will appear within 7 days, and if further
Yes,
IO deserves, I will
in
appear.
future, no such activity.
This one is on him. It and that has been on article. And on billing here, investigating up, comma, code is in time, and pre-arrest bail submitted. To be quick and drive. All right, both disposed of.
Name maybe. My name.
Yes, your name is
S.N. Krishnatra.
in this heard Mr. S.N.
Krishnatra.
Taraya. Causeless is okay. All right.
Plus within 7 days.
Yes, within 7 days.
May please, Lordship. Lordship, I transfer petition, Lordship.
You ready, Mr. Das?
Another thing is that this transfer petition, the private respondent's name is not shown. Whether the service complaint.
That is also taken among the private.
Dusty service was
service.
allowed. What happened after the dusty service?
Have you filed a affidavit?
Affidavit of service to the year. Affidavit. Huh?
ground.
LCR has come. Mr. Das,
My lord.
are you ready today or another day?
Today I have not.
You have not seen? When do you want it?
After a week, my lord.
Uh,
He is on the. There is an interim order. Let it come after the vacation.
list this matter for hearing
after view.
After view. 25/4/2024. Of the attack.
দিব লাগে
FIR at page is the FIR, Lordship, and subsequently sheet was submitted.
FIR is at page?
Page 91. Which was, Lordship, rejected. Against that, I am...
The matter is listed for?
Page 100.
Yes.
Last paragraph I am reading, Lordship. So also dated 2023. Accused Azizullah Khan has paid for discharging him from this case. According to him, the police have falsely implicated him in the above case without his name appearing in the FIR lodged by the informant, and also submitting the charge sheet against him without any reasonable ground. The IO also seized several documents, but not a single also does not support the prosecution case, and therefore, as per section 227 CRPC, if upon consideration of the record and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in this behalf, the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused and record his reason. He has further contended that there is no iota of evidence against him for framing charge, and the evidence collected by the IO is insufficient to frame any charge, and therefore he is entitled to discharge from the case. It is the specific statement of the informant that it were Boidullah, Sanjay Sharma, Nishan Sharma, and Samsullah Khan who had harassed him, and nowhere he disclosed the name of Azizullah Khan, and nowhere he has stated
All right,
that.
we have seen that. Please come show us where the reasons for not discharging.
That your Lordship will find
page 106.
106.
Read from I have gone through.
I have gone through the FIR, Ajahar, Sijarli, CD containing the video message of Binit just before he committed the suicide and charge sheet. I have also gone through the materials in the case diary, especially the statements of the witnesses recorded under section 161 CRPC. I find that the IO has altogether examined 32 numbers of witnesses, out of which 15 of them are
So
mere...
this 5 accused person is including yourself at page 107. Facebook message implicating 5 accused. That 5 persons
The trial court took me as one of them.
is inclusive of you. All
Inclusive
right, proceed.
At the very outset, I must point out that the last Facebook message of Binit that he has implicated the 5 accused persons for his trauma, and the
Mr.
informant...
Ahmed, there are materials against you.
So just one thing, Lordship.
No, I'm reading it at page 107.
Yes, and that
There
paragraph
is
I
no
am reading.
point of reading the entire order.
Lordship. Just one
Towards the
relevant
portion
paragraph.
which is relevant.
Yes,
Page
relevant paragraph I am
107,
pointing
there are
out, Lordship.
materials again, Azizullah Khan.
No, Azizullah
And this
Khan,
is a
they
prayer
are
for
your
discharge.
Lordship.
How can it be discharged at this stage?
So, Lordship, may kindly see one aspect, Lordship, that one I am reading. There is ample materials in the investigation, Lordship. That paragraph.
There is?
Ample material in the investigation. Page 107, middle portion I am reading, Lordship.
Yes,
That,
there is also MPS.
Yes. To show that the FIR named accused Aziz Khan signifies accused Azizullah Khan. Not
Yes.
now this is the case, Lordship. That
You see-
Aziz Khan.
Whether this is true, not true, this will not decide at this stage. Trial court will decide.
But that
The
is why,
principle
Lordship,
is laid down in that case of, what was that case, Mr. Bora? I remember
Yes.
where the principle has been laid down as
Even when in case of discharge,
Justice Chandrachud's decision,
Yes.
if I recollect.
yes, and there maybe 2 views are equally possible in case of discharge also. In that case, the court has to frame the charge.
No, but there is one test, Justice, the old
Old.
Yes, yes.
Yes, father.
Yes,
Yes,
No, but there, where the principle has been laid
Yes,
down,
discharge.
the test.
Yes.
If I remember correctly, we'll have to accept this as
And there is a subsequent judgment also, my lord. So he has to show that in a case of
No
302,
absolutely
my lord, this grave suspicion. If there is a
correct.
suspicion
That
and the grave
suspicion has to
suspicion.
be exactly. There has to be a difference. Now
Difference.
here there are some materials which indicates
I have therefore enclosed the statements your Lordship may kindly see. I can place before the where my names appear. Supposedly
we will
accept,
not
Lordship.
go into all that at this stage. In the
No,
from the
still all right.
order itself shows that the
His case is that he is Aziz, not the Azizullah. That has to be decided by the trial
If you are
court.
innocent in the trial, if there is
If
no
he is not
material
the
against
person
you,
concerned,
yes. Why at this stage we should interfere?
his court cannot validate whether the Aziz and Azizullah is the same and the different person.
Yes.
Because, and the statement also, apart from the search sheet and the Aziz, specific statement by the informant, his case, my lord, Azizullah has been named. Lordship, kindly see the page, only one page, my lord, I am showing the statement, the page 87. And page 57 is the type copy, my lord.
1 second.
57.
Page 57.
Yes, type copy. It is the Mohabir Bagaria, my lord.
Yes.
Then Lordship kindly come to page 58. He is the informant.
Yes.
I'm just reading. Then immediately I went to AMCS to show the Vinit and he became unable to speak. I asked Kailash Bagaria if there is any recording. He then sent me the recording. The accused person on this case, namely so-and-so, Nishan Khan, so-and-so, and Azizullah Khan are completely responsible for the death of the Bagaria.
Lordship may kindly see that for framing charges under section 227, there has to be grounds for presuming. Now, what are the grounds? Lordship may kindly say that he is giving his finding that Azizullah Khan is involved. But how he is involved? Because section 306, there has to be abatement or conspiracy.
There cannot be a mini trial at the time of discharging.
For discharging, there are grounds, Lord. Just as your Lordship has said, Lordship, just I am having that judgment, I am placing for your Lordship.
Which judgment?
P. Vijayan, Lordship.
Which judgment, Mr. Ahmed?
P. Vijayan versus State of Kerala, that guidelines are there, how to, that charges has to be framed. That 7 guidelines are there, Lord.
Where are the decisions of discharge?
No, that if there is no ground for presuming, Lord, only that much. May I see?
Paragraph?
Para 10 and 12, Lordship. Before considering the merits,
yes.
Before considering the merits of the claim of both the parties, it is useful to refer to section 227 of the Code of Criminal Procedure. So, discharge. If upon consideration of the record of the case and the documents submitted therewith, therefore I am saying that record were there, the documents were there. They have to peruse the documents. And after hearing the submissions of the accused and the prosecution in this behalf, the judge considers that there is not sufficient ground for proceeding against the accused. He shall discharge the accused and record his reasons for so doing. If 2 views are possible and one of them give rise to suspicion only, as distinguished from grave suspicion, the trial judge will be empowered to discharge the accused, and at this stage is not.
There are grounds to proceed, Mr. Ahmed, in your case. These are contextual. These decisions are, the principles have been laid down, but you have to apply them in the context of your case, correct? Now, in your case, there is already grounds. There are reasons to proceed.
But if
this is not a case of a mere suspicion. Your name has been said. This witness at page 57 have clearly said after the recording, so and so, and in that your name is also there.
Yes.
Now, whether this, the pros and cons of these evidences will not be considered at the time of considering the discharge application under section 227. Correct, Mr. Ahmed?
Yes, that I understand. But no, Lordship may kindly see the first FIR.
If it was a case where completely there was a lack of application of mind, definitely this court would have interfered. But here the court has applied its mind, discretion, found there are sufficient cause.
But one aspect, Lordship may kindly consider that in the page 107, what I have pointed out, Lordship, that it is said Aziz Khan.
What do you have to say at page 57, page 58? The accused persons of this, he then sent me the recording. The accused persons of this case, namely so-and-so, so-and-so, and Azizullah Khan, are completely responsible for the death of so-and-so.
So, Lordship may kindly see that...
no, what do you have to say to this? Are you saying that this court should not take cognizance of this evidence?
So that then, Lordship can, but if your Lordship...
This is sufficient material.
But if that finding, that what he is saying, Lordship, that Azizullah Khan completely responsible for the death of Vinit Bagaria, if that is borne out of record, Lordship, then I have nothing to say. But if your Lordship see the background of the case, that from initial
This
stage,
court is not going to see the background at this stage. Whatever is there on materials on record, that will be seen.
So, but for framing of charge, that materials which were placed by the investigating officer, that has to be appreciated, Lordship. And therefore, I have submitted that Azizullah Khan and Aziz Khan, it is nowhere said in the investigation. Therefore, I have
According to you, they are two different persons.
That two different. So, Lordship may kindly call for that case diary and only to that extent, Lordship. Whether if there is any material to show that this is the same, because if your Lordship see the statement of other witnesses.
Where have you said this before the trial court? To me, that part of your argument.
That your Lordship will
find. Person, and how is that been dealt with?
That I have said, Lordship, no witnesses named me. That your Lordship will find in page 100.
Where have you said that Ajijul and other name you said is Ajiz? Or what?
Aziz.
Are there two
Aziz
different
Khan.
persons? Where have you said that?
That is specific, it is not there. I have said, Lordship.
You are not even making that argument. Now you are saying it here.
Lordship, may I kindly see 106, paragraph, page 106.
Yes.
Last paragraph I am reading, Lordship.
Yes, yes.
It is the specific statement of the informant that
Page 106.
101, Lord. Sorry, 101 last
Yes,
paragraph.
yes.
It is the specific statement of the informant that it were Baidullah, Sanjay Sharma, Nishan Sharma and Samsullah Khan who had harassed him, and nowhere he has disclosed the name of Azizullah Khan, and nowhere he has stated that Azizullah Khan has abused him over phone. And even in the FIR as he has submitted before the SP on 8/7/2000, the informant has merely stated that his...
These are your contentions, I think.
Lordship, just next, that some Ijaz Khan. Initially there was some
You see,
Ijaz Khan.
this is the contentions.
Lordship.
But here you have.
Yeah,
said.
it is the next line, but he is not disclosed the
Ijaz
name.
Khan.
Lordship.
This is your submission.
Yes. That
Now-
Lordship. Now simply it is said, Lordship, page 107 your Lordship will find therefore ample material in the investigation to show that the FIR
Who is the petitioner? Ajizullah Khan.
Azizullah Khan is the
Is the petitioner.
before your Lordship. And even if your Lordship will find that Ijaz Khan's father name is different, he is from a different village. So how
The court has taken considered your submission and said Aziz Khan and Ajizullah
Yes,
Khan is one.
same. One. That
Then-
is the finding of the court.
Yes,
And my submission
and at page 57, Mahavir Bagaria has also pointed out from the recording that it is Ajizullah Khan is involved. And you are Ajizullah Khan?
I am Azizullah.
So there is materials against you then.
So only that aspect, whether from the record it appears, Lordship, that Azizullah and Aziz Khan are same or not. Only that aspect, Lordship.
That aspect the court has already looked into it. I don't think you have made out anything. Made out a case for this court to go
Kind
into.
of a plea of alibi, my lord. But he is taken. That I was not this person, my lord.
No,
that
but
has to be decided by the trial court, my lord.
Even at the time of discharging, considering discharge, court has taken this point into account and the court says he is one person.
Yes.
The court has acted on it. Now, if tomorrow during trial you prove it is two different persons, of course you will be acquitted.
Definitely, madam.
But why at this stage we will get into all
My
this?
submission to your Lordship
Sorry,
is
Mr.
that-
Ahmed.
just one submission, Lordship.
Mr. Bora, you want to add anything?
No, man. My case is that that dispute has to be resolved during the trial. There is no scope here, my lord. Factual dispute, my lord. It's absolutely factual dispute. And the 161 is the material concern right
See,
now,
Mr.
my lord.
Ahmed, this court is of the opinion that the court has exercised its discretion and applied its mind and has passed a reasoned order. This court does not find any reason to interfere with that finding. There are materials, and if there were no materials, it would have been another thing. But there are materials.
So just one submission, Lordship, that they have frame charges under section 106, and whether that experience is there or not, because they
Very
have
well.
only
Take your
named
seat, Mr. Ahmed. We've heard you.
that Arnab
Heard Mr. A. Ahmed, learned counsel for the petitioner. Stopped. Also heard Mr. A. M. Bora, learned senior counsel, assisted by Mr. B. A. B for victory. B. A. Chaudhary, learned counsel, hearing for respondent number 2. Stop. Also heard P. Borthakur, learned APP for the state respondent. Stop. This is an application under section 482 of Code of Criminal Procedure 1970, read with Article 27 of the Constitution, for quashing of the order dated 29/5/2023, passed by the learned Judge Brugger in session case number 349/2022, whereby prayer of the petitioner for discharge from criminal charges was rejected and framed charges under section 120 capital 306 of IP against the petitioner. So, the case of the petitioner is that on 1/7/2022, one Vinit Bagaria, within brackets since deceased, lodged an Ejahar against Aidullah Khan and Sanjay Sharma, alleging that they were threatening with dire consequences. Thereafter, the father of the deceased, Kailash Bagaria, lodged another Ejahar on 5/7/2022 before the Superintendent of Police Dibrugarh, alleging that Baidullah Khan, Chand Sharma, Sanjay Sharma, along with some other persons, attempted to break their house premises, also gave life threats. Stop. It is further alleged that thereafter on 7/7/2022, Vinit Bagaria committed suicide, and thereafter the father of the deceased, Kailash Bagaria, again lodged another Ejahar on 7/7/2022 against the Aidullah Khan, Sanjay Sharma and Nishant Sharma, alleging that owing to all misdeeds, physical and mental torture meted out to Vinit Bagaria, the latter lost his life. Stop. Accordingly, a case was registered, i.e. Dibrugarh PS case number 390/2022. The it is further stated that the investigating agency submitted charge sheet on 1/9/2022 in connection with Dibrugarh PS case number 390/2022, arising out of information dated 7/7/2022. Stop. It appears that it is the further case of the petitioner that during investigation, the investigating officer recorded the statement of various witnesses under section 161 CRPC, and after completion of the investigation, the investigating officer filed charge sheet on 1/9/2022, being charge sheet number 337 of 2022 under section 306/34 IPC, headed section 120 307 IPC, before the court below against 5 persons, including the petitioner. Stop. Thereafter, on 29/5/2023, the trial court framed charges against the accused persons, including the petitioner. Stop. Though the petitioner had filed a petition under section 227 under CRPC for discharging him in the case, the learned additional session judge Dibrugarh, after hearing the party rejected said application by the same order dated 29/5/2023. Stop. Aggrieved by the said order, the present criminal petition has been filed. Stop. Mr. E. Ahmed, Senate Counsel for the petitioner, submits that Ajizullah Khan, within bracket petitioner, is not the B. Ahmed, Learned Counsel for the petition, submits that the petitioner has not been named in the FIR. Stop. He further submits that the father of the informant has categorically said that only 4 persons are involved and the name of the petitioner is not disclosed in statement of the father. Stop. He further submits that the petitioner is not Ijaz Khan, who is disclosed by the witnesses to be involved in the alleged in the case in hand. Stop. Mr. A.M. Bora, the senior counsel, on the other hand, poses the prayer for quashing the aforesaid order of discharge. Stop. He submits that the session court, right? Additional session. He submits that the criminal court has applied its mind and by reasoned order has rejected the prayer for discharge under section 227. Stop. CRPC. Stop. He further submits that there are materials available implicating the petitioner for the charge for the offences charged. Stop. Mr. P. Borthakur, learned APP, further also opposes the prayer. Stop. He further submits that there are materials available on record in implicating the accused of the offences alleged. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Before considering the merits of the claim of both the parties, reference is made to section 227 of the CRPC, which reads as hereunto, quote unquote 227. Mr. Bora, can your junior find out that decision of Justice Chandrachud? I think it is of 78 in the line of 227. Just try in your phone if you can get it. I think it is of 68 or 78 of Justice Chandrachud. If you get it, you can just pass it to my co. It is clear that at the stage of section 227, the court has to exercise his judicial mind to the facts of the case in order to determine whether a case for trial has been made out by the prosecution or not. Stop. In assessing this fact, it is not necessary for the court to enter into the pros and cons of the matter or into a weighing and balancing of evidence and probability, which is otherwise the function of the court after the trial starts. Stop. At the stage of section 227, the court has to merely see as whether or not there is sufficient ground of proceeding against the accused. Stop. Stop. Reference is made to decision of the apex court in the case of State of Bihar versus Ramesh Singh, reported in 1977 4 SSC 39, which reads here, which is expected hereunder for any reference. Quote unquote direct quote. Thus, it is apparent from the aforesaid decision that at the time of framing charge, strong suspicion itself is sufficient in order to frame a charge. Stop. In the present case, it appears from the statement of witness Sri Mahabir Bagaria that he has clearly stated in his statement recorded under section 161 CRPC that from the recording, this recording is made by the deceased before dying.
Yes.
That from the recording made by the deceased before committing suicide records the name of the petitioner along with the other co-ed. The aforesaid statement is annexed to the criminal, is enclosed at page 57 of the, this is part of the criminal petition? Of the criminal petition. Stop. Perusal of the impugned order dated 29/5/2023 shows that the Court of Additional Session Judge so and so, while rejecting the prayer for discharge under section 7 CRPC, has judicially taken notice of the fact that there are materials which are sufficient against the petitioner for sending a trial. Stop. The aforesaid order is reasoned. Is reasoned. Stop. In view of the above, this court finds no merit in the criminal petition warranting interference with the order of the additional session judge. Additional session judge, where it's not mentioned down.
Post title I have written.
Post title. Additional session judge Dibrugarh in session case number so and so. Order dated 29/5. Accordingly, criminal petition stands dismissed.
Obliged.
Yes.